Okay, stay with me here because this is important. Something happened. Something strange happened yesterday afternoon, and almost no one noticed it in real time. Around the late hours of the day, phones that normally never stop buzzing inside Donald Trump's legal orbit suddenly went quiet. Not the "we're drafting a response" kind of quiet. Not the strategy meeting in progress kind of quiet. This was different. This was the silence you get when a plan doesn't just fail, it disintegrates all at once. The reason traces back to a decision that landed quietly while most of the country was asleep. A decision that didn't scream for attention, didn't come with dramatic leaks or flashing headlines at first, but may go down as one of the most devastating legal blows ever dealt to a former American president. Because with one ruling, the Supreme Court didn't just reject an argument. It didn't just narrow a defense. It effectively erased an entire legal shield that Donald Trump has been relying on for years. A shield built out of delay, privilege claims, immunity theories, and procedural fog. Gone. Not weakened, gone. And here's the part that should make everyone pause for a second. This wasn't a narrow decision. It wasn't split along ideological lines. It wasn't 5-4. It wasn't even 7-2. It was unanimous. Every justice, including the ones Trump personally put on the bench, the people widely assumed to be his backstop, his safety net, his last line of defense. Before we go any further, understand this. What I'm about to walk you through is not the version of this story you're hearing in clips or headlines. Those are surface-level summaries. The real impact of this ruling lives in the mechanics: deadlines, standards of proof, exceptions buried in footnotes, and consequences that cascade across multiple courts at once. And by the end of this video, you'll understand why legal experts are saying the next 2 weeks could determine not just Trump's future, but the future boundaries of presidential power in America. Now here's where things get unsettling. The ruling everyone is talking about, the one you can download online, that's only part of the picture. There is another component, a supplemental section that is not public, not searchable, not discussed on television. A sealed addendum reviewed only by the justices and the attorneys directly involved. According to people familiar with its contents, it contains material so sensitive that even summarizing it publicly would cause immediate legal consequences. And inside that sealed material is a specific section that could independently justify new criminal referrals, not hypothetically, not down the road, but immediately. And that helps explain something else that doesn't add up at first glance. Earlier drafts of this decision looked very different. Inside the Supreme Court, draft opinions circulate weeks before a final ruling. That's normal. Justices signal disagreements. Dissents get written. Coalitions form and fall apart. In this case, early drafts reportedly included a sharp defense of presidential immunity, one that leaned heavily on history, separation of powers, and the dangers of criminalizing executive decision-making. More than one justice was initially sympathetic to that view. Then something happened. In early January, the justices received a closed-door briefing from the Department of Justice. Classified, no press, no transcript, no leaks. The topic wasn't politics, it was national security, and the briefing wasn't short. It stretched on for hours. When it ended, everything changed. The draft dissent disappeared. Justices who had been leaning toward carving out protections reversed course. Arguments that once seemed plausible were abandoned entirely, and when the final ruling was released, it spoke with a single voice. 9 justices, 1 conclusion. That alone should tell you how serious this is. We still don't know what was shown in that briefing, but we do know this. Whatever evidence was presented was strong enough to override ideology, loyalty, and decades of judicial caution around presidential power. Now let's talk about the clock. Because this ruling didn't just settle a debate, it started a countdown. Buried deep inside the opinion is a response deadline. A short one. Trump has a limited window to formally reply, not with press statements, not with campaign rhetoric, but with legal filings that carry real consequences. Here's the problem. Multiple constitutional scholars say responding may be legally self-destructive. Why? Because any substantive defense he offers now risks contradicting positions taken in other cases. And those contradictions aren't theoretical. They could be used as admissions in ongoing prosecutions across different jurisdictions. In other words, defending himself in one court could incriminate him in another. That's why you're seeing what looks like paralysis. It's not indecision. It's a recognition that every move makes something worse. To understand how this happened, you have to rewind and look at a series of choices that seemed smart at the time, but quietly set a trap. The first was betting everything on immunity. After lower courts rejected Trump's claim that a former president cannot be prosecuted for actions tied to official duties, his legal team had options. They could pivot, narrow the argument, focus on factual disputes. Instead, they doubled down. They pushed the issue all the way to the Supreme Court, convinced that the conservative majority would at least slow things down. The delay came, but not the way they expected. For months, there was no ruling, no clarification, no signal. And that silence was misread as hesitation. It wasn't. It was alignment. Behind the scenes, the court wasn't struggling with whether to protect Trump. It was working out how to write a decision so definitive that no future president could try the same maneuver again. Which brings us to the second miscalculation, underestimating witnesses. Public attention has focused on high-profile figures, former chiefs of staff, cabinet members, elected officials, but some of the most damaging testimony comes from people whose names never make headlines: staffers, assistants, observers. There is at least one cooperating witness whose role places them in rooms Trump has publicly claimed he was never in. On calls, he says, never happened, during moments when decisions were made in real time as events spiraled. This individual didn't rely on memory. They kept records, extensive ones, notes taken as events unfolded, not reconstructed later, timelines that match phone logs, details that align with security footage, a contemporaneous paper trail that prosecutors love and defense attorneys fear. That evidence didn't disappear. It's been quietly integrated across cases, which leads to the third error, assuming the focus was federal. While national attention stayed fixed on Washington, another case was taking shape under state law. Different standards, different rules, no federal pardon power, no constitutional shortcut, and the Supreme Court's ruling didn't stop at federal boundaries. It explicitly applied its reasoning to state proceedings as well, which means defenses that were supposed to survive in one courtroom evaporated everywhere at once. That realization is now hitting hard, because state timelines move differently. They don't wait for elections, they don't pause for political convenience, and once they start, they're much harder to stop. The fourth oversight was financial. Criminal exposure dominated the strategy, but civil judgments were quietly stacking up in the background. Massive ones. Judgments that had been temporarily stalled by the same immunity arguments now erased. With those barriers gone, enforcement becomes mechanical, not dramatic, not political, just procedural. Deadlines, liens, seizures. That pressure isn't theoretical, it's calendar-based. So what options remain? Privately, Trump's team has been cycling through scenarios. None are clean. One possibility was asking an individual justice to pause the ruling. That attempt was made. It failed fast. So fast it signaled something important. Whoever reviewed it already knew what was in the sealed material. Another idea involved reviving arguments about political questions, claiming courts shouldn't intervene. That path was preemptively closed by the ruling itself, which leaves the most extreme idea of all, challenging the court's authority outright, not appealing the decision, not narrowing its scope, questioning the legitimacy of the institution itself. That's not a legal strategy. It's a constitutional rupture. And several attorneys have reportedly walked away rather than put their names on such a filing. That alone should tell you how dire this has become. To understand why legal scholars are calling this ruling a seismic shift, you have to look at how carefully it was written. This wasn't emotional language. This wasn't rhetorical. It was surgical. Every sentence appears designed not just to resolve one case, but to lock doors behind it. One of the most consequential sections deals with a question courts usually avoid touching directly: whether any person who has held the presidency can claim a special shield from criminal accountability after leaving office. Instead of dancing around it, the court answered it head-on. The opinion makes clear that holding the highest office in the country does not place someone beyond the reach of criminal law for conduct that falls outside legitimate governing activity. And it doesn't stop there. The language deliberately eliminates wiggle room. There's no suggestion that this applies only in extreme cases. There's no hint of future balancing tests. It's categorical. And that matters because for years, Trump's defense strategy relied on blurring the line between public duty and private action. If everything could be framed as official, then everything could be shielded. That framing just collapsed. Here's a detail most people missed. The court didn't just reject immunity. It redefined how intent is evaluated when a former president claims they were acting in an official capacity. In ordinary criminal cases, prosecutors often need to prove that a defendant knowingly broke the law. That's a high bar. But the court acknowledged something unique about presidential power. Presidents are constantly warned. They are surrounded by lawyers. They receive briefings, memos, and cautions precisely because their actions carry legal consequences. So the court adopted a different standard in these circumstances. Instead of requiring proof that a former president knew an action was illegal, prosecutors may now show that the president ignored clear warnings, dismissed legal advice, or proceeded despite being told their conduct crossed legal lines. That shift cannot be overstated, because in Trump's case, there is documented evidence that senior legal advisors repeatedly flagged issues with post-election actions. Not once, not twice, over and over again, in meetings, in writing, in front of witnesses. Under the new standard, those warnings aren't just background noise, they're evidence. And this change ripples outward. It doesn't just affect one charge or one jurisdiction. It lowers the burden across multiple cases simultaneously. Then there's executive privilege. For decades, executive privilege has been treated as a near sacred doctrine. The idea is simple. Presidents need confidential advice. If aides fear future exposure, candid counsel disappears. Courts have traditionally been extremely careful not to puncture that shield. Until now. The ruling introduces a sweeping clarification. Communications lose protection when they are used to facilitate unlawful conduct. This concept isn't new in law. It's long existed in attorney-client privilege, but applying it to presidential communications is groundbreaking. The practical effect is staggering. Conversations that were once considered untouchable can now be examined. Oval Office discussions, Air Force One exchanges, private meetings with senior advisors. If they were part of an effort to obstruct lawful processes, the privilege evaporates. This doesn't mean everything becomes public automatically, but it does mean judges can review these materials privately and decide whether protection applies. Which brings us to one of the most dangerous traps embedded in the ruling. When a former president claims certain documents are privileged, the court now requires those documents to be submitted for judicial review. Not summaries, not descriptions, the documents themselves. If a judge determines the materials show evidence of criminal conduct, they can be released to prosecutors. So Trump faces an impossible choice. Hand over documents and risk them becoming evidence. Or refuse and risk contempt, obstruction, and additional charges. There is no neutral option. Now let's zoom out and look at the calendar, because this is where the pressure becomes relentless. Within days, Trump must decide whether to comply with document production requirements. This isn't something that can be delayed indefinitely. The Supreme Court has spoken. Lower courts are expected to act quickly. Soon after, a state court is scheduled to address trial timing in a racketeering case involving multiple defendants and dozens of charges. That court has already signaled it wants to move fast. Not long after that, a federal judge is expected to reset a long-delayed trial date that was paused solely because of immunity appeals that no longer exist. And overlapping all of this are civil judgments that are transitioning from paper rulings into enforceable actions, liens, collections, asset seizures. These processes don't care about campaigns or narratives. They move when deadlines expire. Here's what makes this uniquely dangerous for Trump. Each case feeds the others. Testimony in one proceeding can be used in another. Documents produced under court order don't stay siloed. A conviction in one jurisdiction affects juror perception in the next. Momentum builds. This is not one storm. It's a convergence. Now, to be fair, let's address the strongest arguments from Trump's side, because ignoring them doesn't make them disappear. The first claim is that this is all political, that the timing is suspect, that prosecutions accelerating during an election year undermines democratic choice. On the surface, that argument resonates emotionally. It feels uncomfortable. No democracy enjoys prosecuting former leaders, but intent matters, and evidence matters more. The question isn't whether the cases are unprecedented. They are. The question is whether the conduct was unprecedented. Courts don't prosecute people for being unpopular or disruptive. They prosecute based on evidence, recordings, documents, witnesses, timelines. If the standard became never prosecute a former president, the presidency would become a legal fortress. That's precisely what the court rejected. The second argument is bias, that institutions are stacked, that even conservative judges have been compromised. But that theory collapses under scrutiny. Judges appointed by Trump himself rejected his claims. Officials from his own party testified against him. Advisors he selected warned him. State officials who voted for him refused to bend. Conspiracies require coordination. This situation shows fragmentation. The third argument is that using courts in this way risks tearing the country apart. That concern is real. But the alternative is worse. A system that refuses to apply law to power eventually loses all credibility. Democracies don't collapse when leaders are held accountable. They collapse when leaders aren't. Which brings us to the crossroads ahead. There are three paths this could take. In the first, institutions hold, cases proceed, evidence is tested publicly, verdicts are rendered by juries. The outcome, whatever it is, carries legitimacy because process was followed. In the second, pressure overwhelms the system. Delays, intimidation, and procedural sabotage prevent resolution. The message becomes clear. Power insulates itself. Accountability becomes optional. In the third, the system fractures. Different courts reach conflicting outcomes. Trust erodes, legitimacy splinters, law becomes partisan terrain. None of these paths are abstract anymore. They're being shaped right now by filings and rulings most people never read. And here's what to watch next. If former legal advisors begin speaking publicly, it suggests privilege barriers have fallen. If certain witnesses are scheduled quickly, prosecutors are accelerating. If political allies suddenly stop defending Trump, it's because they've seen something they can't explain away. We are no longer in a slow-moving story. We're in a compression phase. Everything is happening faster now because the barriers that once slowed it down have been removed. That's not a legal strategy. It's a constitutional rupture. And several attorneys have reportedly walked away rather than put their names on such a filing. That alone should tell you how dire this has become. When historians look back at moments where power finally met resistance, they usually point to a single event: a court ruling, a resignation, a verdict. But in reality, those moments are rarely singular. They're sequences, pressure building quietly, then suddenly accelerating faster than anyone expects. That's exactly where this situation is now. The next 90 days aren't important because of one trial or one filing. They matter because of overlap, compression, the legal equivalent of tectonic plates grinding against each other until something gives. Here's the part no headline will explain clearly. Trump is not facing one decisive battle. He's facing attrition, a system designed to exhaust defenses by forcing simultaneous responses in multiple arenas, each with its own rules, timelines, and consequences. And unlike political scandals, these processes don't pause for rallies, polls, or messaging resets. They run on calendars. Within weeks, courts will begin enforcing deadlines that were previously theoretical. Judges who had been waiting for higher court guidance now have it. Prosecutors who were holding evidence in reserve no longer have to, and defense teams that relied on delay as oxygen are running out of air. One of the most underestimated factors here is testimony momentum. Once witnesses begin testifying under oath in one case, the dam doesn't just crack, it breaks. Statements become locked in, inconsistencies get mapped. Prior silence becomes suspicious. Every transcript becomes discoverable. And that's where this becomes uniquely dangerous for Trump, because his public narrative has been expansive, absolute, repeated. When those statements collide with sworn testimony, judges don't treat them as spin. They treat them as potential contradictions. That's how perjury traps form, not because someone intends to lie under oath, but because they've already committed to a version of events that can't survive cross-examination. Another accelerant is financial pressure. Legal defense at this scale is not just expensive, it's relentless. Motions, appeals, expert witnesses, multiple jurisdictions, parallel teams. Even billionaires feel the squeeze when judgments turn enforceable. And when assets are frozen or seized, strategy changes. Choices narrow. Negotiations that once seemed impossible suddenly become attractive. That's often when cooperation expands. People forget this, But major cases rarely turn on one star witness. They turn when several secondary figures decide survival matters more than loyalty. When timelines converge and consequences become personal, silence stops being heroic. Now let's talk about the political dimension. Not in terms of talking points, but institutional reality. There is a widespread belief that elections automatically halt prosecutions. That's not true. Courts do not pause because ballots are printed. Judges do not suspend hearings because campaigns are underway. If anything, courts accelerate to avoid the appearance of interference. That creates a paradox Trump's team hasn't solved. Delay used to be the strategy. Now speed works against them. And here's something else few people are considering: jury psychology. In one isolated trial, jurors can be persuaded that the case is exceptional, politicized, unfair. But when multiple juries in different places hear overlapping evidence, patterns emerge. Consistency matters. Repetition reinforces credibility. By the time later trials occur, earlier testimony has already shaped public understanding. Even jurors instructed to ignore outside information are human. Context seeps in. This is how legal gravity works. The system doesn't need to rush. It just needs to keep moving. Now let's address the scenario everyone whispers about, but avoids discussing openly. What happens if Trump defies a court order? Not rhetorically, not symbolically, procedurally. Defiance doesn't look like a speech. It looks like non-compliance, missed deadlines, refused document production, ignored subpoenas. Courts respond to that the same way they respond to anyone else: sanctions first, then contempt, then escalation. No one wants to see a former president in that position, judges least of all. But the machinery doesn't stop because a defendant is famous. And that's where this story stops being about Trump alone. Because every future president is watching. If defiance works, it becomes a blueprint. If it fails, it becomes a warning. That's why the Supreme Court wrote this ruling the way it did. Not loudly, not emotionally, but firmly enough to survive decades. They weren't just resolving a dispute, they were setting a boundary. Now, let's talk about outcomes. Not predictions, but possibilities. One outcome is full accountability. Trials proceed, verdicts are reached, appeals follow. The system demonstrates that power doesn't equal immunity. The cost is turbulence. The benefit is legitimacy. Another outcome is partial collapse. Cases drag. Conflicts between courts deepen. Public trust erodes unevenly. Law becomes regional. Outcomes depend on geography. That scenario doesn't end with clarity. It ends with normalization of chaos. And then there's the darkest outcome: precedent inversion. If Trump escapes consequences, not because evidence is weak, but because institutions bend under pressure, the lesson is devastating. It tells future leaders exactly how far they can go and how to protect themselves afterward. History shows what happens next in those systems. Power stops transferring peacefully. Law becomes ornamental. Loyalty replaces legality. That's not speculation. It's pattern recognition. So where does this leave us right now? At a hinge point. Over the next several weeks, a handful of decisions will reveal which direction things are moving. Not speeches, not polls, decisions. Watch who files motions and who doesn't. Watch which attorneys withdraw. Watch which witnesses appear sooner than expected. Watch when language shifts from certainty to caution. Silence will be louder than noise. And above all, watch the courts. They are moving more deliberately than the news cycle, but far more decisively than many realize. This isn't a closing-in metaphor anymore. It's a narrowing of options. Trump still has choices, but every choice now carries consequence. There is no move left that doesn't cost something significant. That's the difference between political crisis and legal reckoning. Before I wrap this up, let me say this clearly. No matter where you stand politically, this moment matters. Not because of who is involved, but because of what is being tested. The limits of power, the resilience of law, the question of whether rules apply evenly or selectively. Those questions don't belong to one party. They belong to the country. If you want to stay ahead of this story, not the sensational version, but the real one unfolding inside courtrooms, make sure you're subscribed. Hit like if this breakdown helped you understand what's actually happening, and share this with someone who thinks this is just politics as usual. It's not. And I want to hear from you. Do you think Trump will comply with the courts as pressure mounts, or do you think he'll gamble on defiance and force a constitutional showdown? Drop your thoughts in the comments. I read them, I respond, and I'll be back with the next update as soon as the next domino falls. We are no longer in a slow-moving story. We're in a compression phase. Everything is happening faster now because the barriers that once slowed it down have been removed. That's not a legal strategy. It's a constitutional rupture. And several attorneys have reportedly walked away rather than put their names on such a filing. That alone should tell you how dire this has become.